Welcome to the Bloomberg Law Bankruptcy Review. I'm Lee Pacchia. The National League beat the American League in last night's All-Star game, if you were watching, taking the lead on a three-run home run blast. That said, we're joined by the Prince Fielder of Priority Claims, Bill Rochelle. He's a bankruptcy columnist for Bloomberg News. Good to see you. Welcome.
Good day.
All right, so two items to run through. We have an opinion out in the Bearing Point case in front of Judge Gerber in the Southern District of New York Bankruptcy Court. It adds color to the Ann Nicole Smith decision that came down from the Supreme Court a couple weeks back. What to make of it? This raised a lot of jurisdictional issues. We're interested to see how this was going to play out in bankruptcy courts. How bad is it?
Well, very interesting opinion by Judge Gerber, one of the fine bankruptcy judges in New York. This is a first major opinion to interpret what it really is that the Supreme Court said. Less than a month ago, the big court in Washington ruled that it was unconstitutional for bankruptcy judges to make binding rulings on state law claims. And Gerber's decision, bankruptcy judge here in New York, is really the first major decision exploring what it means. When that opinion first came down from the Supreme Court, I drew the conclusion that I thought it was a really big deal and that it was going to dramatically change the practice in the bankruptcy courts. I thought and still think that it's going to take, say, 2 to 4 years to really figure out how dramatic the change is. There were some folks that disagreed with that notion, thought bankruptcy judges would be able to paper over it, and it really wouldn't make much difference. But Judge Gerber came down in his opinion, indicating to me that it is a big deal after all. What he said in his decision in a case called Bearing Point was that even though the defendant might not want the case taken out of his court right then, Gerber ruled that it had to go to a state court. That it was likely to be unconstitutional for him to rule on this case.
And what type of issue was at stake here?
It was a state law issue where people wanted to sue directors and officers of a bankrupt company. A plain old common garden variety state law question. And he said, no, I don't want it because we may be wasting everybody's time if we go way down the road. He said also, there's going to be no amount of trouble because people are going to be fighting over jurisdiction until the cows come home. And I don't want to waste people's time, he says. This case is going to get over with much more quickly without all this jurisdictional hoo-ha if we simply send it off now to a state court in Virginia, and that's exactly what he did.
So this could be the beginning of a very, very tricky issue for the whole bankruptcy court system.
You betcha.
State court issues come up in bankruptcy.
All the time. And Gerber also said, this I thought was very important, that this constitutional defect cannot be waived even by the defendant. In other words, he said, the defendant could lie in the weeds for months, maybe years, consenting to going ahead in the bankruptcy court, and then suddenly at the end of the day, if the result is wrong, raise up and say, oops, no, by the way, you never had jurisdiction or power in the first case, so everything we did here is void.
Right. Very interesting to watch this one play out. Let's touch on the Omega case. It's a Greek shipping company that filed in Texas. Earlier, you were wondering if this case belonged in the United States bankruptcy court system at all. What do you think of it now?
Well, that's right. I am still wondering, and I was also curious about whether I was completely out in left field in my opinion on this, but apparently not. For a little background on it, this company, Omega Navigation, owns, I think, 8 big double-hulled petroleum tankers. It's a Greek company, at least based in Athens, has probably not much in the way of connections with the United States, but they're in a big fight with their lenders. They sued the lenders in Greece, of all places. However, when push came to shove, they filed bankruptcy in Houston, Texas. So it dawned on me that, maybe this is not a proper use of the U.S. bankruptcy system if this company doesn't have much connections with the U.S. So I went out on a limb and allowed as hell, well, maybe this ain't the way it should be. Well, it didn't take too long before the secured lender owed almost $250 million, filed papers in bankruptcy court, dropped a very pregnant footnote in these papers, and said they were reserving their rights about the whole issue of whether or not the case is proper in the United States and whether or not it ought to be dismissed. And I'm kind of hoping, just out of a question of intellectual interest, that they go to bat on this. Usually when similar cases are filed, people sort of sit around and decide, well, heck, being in the U.S., although it's maybe not the right place, is a darn sight better than maybe being in a third world country or Lord knows what.
Right.
So everybody just decides to go ahead in the U.S., or they use the threat of dismissal in the U.S. to force a settlement.
Right. People like our bankruptcy courts.
Well, that's right. Nice place to be.
All right, good enough. All right, Bill, thanks for that. That's Bloomberg News columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. I'm Pacchia. Thanks for watching.